There is a widespread belief that if someone posts factually accurate information about you on the internet, you are legally powerless to stop them. Imagine a disgruntled former employee or an angry ex-partner deciding to ruin your reputation. They don't have to lie. They can simply upload real internal documents, private facts, or sensitive court records for the world to see. Because the material is genuine, victims often assume they cannot sue. Defamation law requires a statement to be false, so abusers specifically use the truth to avoid being taken to court. This creates a situation where traditional libel suits are ineffective. By sticking to the facts, an attacker can bypass defamation law entirely, leaving the victim feeling trapped by the very truth of the situation. To stop the weaponization of private facts, the actual tool required is the UK's Protection from Harassment Act 1997. This law focuses on the impact of a person's behavior, not just the strict accuracy of their words. The specialist internet law firm Cohen Davis Solicitors successfully demonstrated this strategy in a high court case, securing an injunction against a relentless digital abuser. Their victory proved a critical point. Under UK law, if a publisher's behavior is calculated to be oppressive and cause distress, the factual accuracy of their statements will not protect them from a court order. The events of this case unfolded at the highest levels of international diplomacy. The target was a senior, long-term employee at the International Maritime Organization, a branch of the United Nations. The harassment campaign was launched by a junior temporary interpreter whose short-term contract at the agency was not renewed. Before leaving, the junior employee initiated an internal human resources investigation. A special committee looked into these allegations and made some minor findings, confirming flaws in the senior employee's management style. Those minor HR findings were factual. The disgruntled former employee then took that real internal report and used it as the foundation for the digital attack that followed. The retaliation was severe. He registered and built 4 separate websites dedicated specifically to branding his former boss as a confirmed abuser. To increase the personal impact, he published unauthorized private photographs of her directly alongside these allegations. This triggered a legal claim known as breach of confidence. Breach of confidence occurs when private information, shared with an expectation it will remain secret, is disclosed without permission. The senior employee had a clear expectation of privacy regarding both the photographs and the internal UN inquiry. While the internal report did sanction her on minor points, the abuser stripped those findings of their context. He exaggerated and sensationalized the details until they were unrecognizable from the original facts. The digital attack soon bled into the physical world, with the former employee handing out leaflets directly outside the IMO headquarters in London. Raising a workplace grievance through official channels is a protected right, but systematically building multiple websites and distributing pamphlets to humiliate a specific person crosses the line into a calculated campaign of oppression. Cohen Davis Solicitors took the case to the High Court in London, forcing a judge to decide whether technically true information could legally constitute harassment. Justice Cranston ruled that even if a website contains truthful information, it can still be the subject of a harassment injunction if its continued publication is calculated to cause alarm and distress. The court accepted a specific metaphor for this behavior, the continuous megaphone. Leaving a website live 24 hours a day is legally equivalent to following someone around and constantly shouting in their ear. The judge applied the oppression rule. Building 4 websites created excessive repetition, shifting the behavior into oppression, meeting the standard for a court order. This ruling establishes that abusers cannot hide behind the accuracy of their statements. The truth is not a shield for harassment. The legal consequences for the abuser were immediate. He was served with a high court injunction and legally forced to permanently delete all 4 of the harassing websites. Cohen Davis also secured long-term protection for their client. The harasser was bound by a formal court undertaking, legally forbidding him from ever repeating those allegations online again. When utilized correctly by specialist solicitors, the legal system has the power to erase a digital vendetta and restore a victim's peace of mind. Whether the information published about you is false, twisted, or factually accurate, nobody has the legal right to wage a campaign of digital oppression against you. Online harassment law is complex. Navigating these legal requirements requires specialist solicitors who know how to secure immediate court orders. You do not have to suffer in silence. Contact Cohen Davis Solicitors today for a consultation to get your life back.